Good morning. It's 11 a.m. My name is Lucia Ward. I am a Research Services Librarian and Diversity Fellow at Cornell University Law Library in Ithaca, New York. Today's session is what can librarians do to facilitate access to justice? My intention here is to start more of a dialogue. We can come up with the answers together. And I have hopefully 3 parts to our program today. A short lecture, then we'll have a question and answer time, and hopefully we will have time to have a whole group discussion. Perhaps you can split off into small groups with the people that you're sitting near, and I have discussion questions prepared, so hopefully there will be time for that. So first, let's begin with access to justice. Access to justice is the ability to bring your case to court and get a fair resolution, or the ability to advocate for your legal rights in situations outside of court and get a fair resolution. And librarians have a lot to do with that, being the information professionals that help people get the information that they need. A few months ago, a patron not affiliated with Cornell came to the library during my reference shift. And she had a letter from the county attorney, and she wanted to know if the county could take her land. She said that she had read every statute that was relevant, that she had researched the case law, and that the county attorney did not cite any law in his letter. Well, I had to tell her that we could not give her legal advice. However, we could direct her to information resources. And she should consider consulting an attorney. And she told me that she did not have money to hire an attorney. I shared with her that there were legal aid options. I also shared with her the website lawhelp.org and the American Bar Association's Find a Lawyer webpage, which lists several bar directories. And that was the conclusion of our reference session. However, this is an example of the justice gap, and the Legal Services Corporation calls the justice gap the absence of a legal resource, and the gap is the space between that resource and the need. So the patron had a need, but she didn't have the resource to meet that need. Now, there's a lot of statistics about the justice gap. So let's just begin with lawyers for the most part. Lawyers are providers of legal services. And according to Glassdoor, which is a human resources company based in Japan, lawyers are some of the highest paid professionals in the United States. On their list of the 2018 top 25 jobs, highest paid jobs in the United States, lawyers are both number 5 and number 22. Also, most people, therefore, can't afford to hire a lawyer. The way our legal system is set up, with very few exceptions, it's the lawyer that has to represent someone in court. Now, according to some statistics, there are about 70 to 98% of people who go to represent themselves in court in civil cases, such as matters dealing with housing, perhaps a mortgage foreclosure, or perhaps they have a family law issue, without a lawyer. The National Legal Aid and Defender Association estimates that 80% of defendants in criminal cases cannot afford a lawyer. Now, this brings us to some other tangential issues that we really won't delve into today, but that are just as relevant. And these are the issues of community justice, community lawyering, and critical legal information literacy. William Quigley has noted that most law schools do not teach community justice and community lawyering. Basically, community justice means that you have a bunch of people who are marginalized. Maybe they're all going through foreclosure, or they are having issues with their landlord. They don't necessarily get together and pool their ideas and their resources to get access to justice. Community lawyering comes in when lawyers actually empower people to advocate for themselves in difficult situations. Critical legal information literacy is knowing where your legal information comes from, how it's relevant, and how important it is. And that is something that Yasmin Sokar Harker advocates for. And she says, especially if law students who intend to be lawyers want to go into the public interest or government service, and they will be serving clients who may not have access to all of the subscription databases that we often use in law school, will definitely need to know how to get open access resources, legal information resources, and know how to think critically about the legal information that they're getting. So we've already gone over the access to justice gap. And so now this brings us to legal information. Legal information consists of general knowledge regarding the law and the legal system. For example, websites maintained by state legislatures, the statutes for a jurisdiction as they are on the shelves in the library, research guides, general knowledge, general information. And we have legal advice. Legal advice is part of what we consider the practice of law. According to the American Bar Association's Model Rule of Professional Conduct 5.5, there is a notation that the practice of law, the definition of the practice of law varies from jurisdiction to jurisdiction. And the actual purpose of this rule, which prevents people who are not licensed from engaging in the practice of law, is to protect the general public from people who may not know what they're doing when they are giving legal advice. So the bar associations typically only want licensed attorneys giving legal advice. Now, many people have said many things about the practice of law. In 1995, John Greason, who was a former director of the Administrative Office of the Courts in New Mexico, wrote the seminal article on legal advice and legal information. And he came from the perspective of people who work in courts, court personnel, such as court clerks. And he pretty much said that legal advice has no inherent meaning. Now, I would actually argue that legal advice is the application of law to facts. I would say that if someone has a fact situation and they say, what should I do? Then, and they're looking at it from a legal standpoint, the person who answers is probably giving legal advice. But John Greason came from a different point of view, and he said that court personnel who help people select court forms, who tell people when they should file their form, are really not engaging in the practice of law. They are acting on the authorization of the court, and therefore, since they are authorized by the court, even though they are not attorneys, what they are doing is okay, it's acceptable, and it's not the unauthorized practice of law. Now, my talk today comes from the perspective of people who work in libraries. And so that context is completely different. And perhaps things that court personnel do would not be acceptable for a librarian to do. So for example, if someone comes to the reference desk and says, which form should I file in court today? A librarian, more than likely, would be engaging in the unauthorized practice of law by answering that question. Even if the librarian is licensed in that jurisdiction, the library will have a policy of, we don't want our librarians practicing law. That's not what we're set up for. So just think about it from that perspective. Libraries have policies that prohibit librarians from practicing law. So, as I was saying, this means no filling out of forms, no choosing forms on behalf of patrons, no defining of legal terms. And typically, libraries will tell their librarians that they should not read the law over the phone to people who have legal information questions. So this brings us to the next part about legal advice. And I have two questions for us to think about as we move forward. Does the state maintain a monopoly on the practice of law? And is the state protecting the public? So I've noted earlier that most jurisdictions have rules on the unauthorized practice of law, and they say in their rules and the ABA has the model rule that, this is here to protect the public. Now, in the literature on the unauthorized practice of law, there have been scholars who have written about other jurisdictions, even outside the US, that have limited legal licensing schemes that allow people who are not lawyers to do defined legal tasks. And they say that the research of these programs shows that customers are satisfied. Right here in the US, we have services such as LegalZoom and Rocket Lawyer that allow people to get legal forms. And in some cases, depending on the plan that they have with these programs, they can get some sort of legal advice. Now, it's quite interesting. There was a program called AVO that provided legal services, and they provided legal services up until June of 2018. The way their business functioned was that it connected lawyers with clients, and it was then left up to the lawyer and the client to decide how they would proceed. AVO did not provide the actual legal forms. That was something that the lawyer had to do. And what happened was this program came under extreme criticism of various bar associations, which led them to discontinue the program. Now, recently, Deborah Rode and Benjamin Barton, like May of 2019, published an article in the Hastings Law Journal that said that, this wasn't such a bad program after all. Probably the bars who actually came out against this program really were looking at the fact that it was creating national fixed fees for lawyers' services. And there have been others, such as Richard Gordon from Stanford Law School, who have said that really bar associations act as guilds, and they control who enters the profession and how they enter and what they can do. So that's another idea right there in the access to justice issue. Now, in 2012, Washington State was the first state to allow limited license legal technicians. And what this means is that they can do defined tasks if they have this license. They can help people fill out forms, and Washington State has started this with its family law program, and it will expand into other areas of high need, such as housing or landlord-tenant issues. Now, there was an article by Rebecca Donaldson, and it's recent, within the last 2 years, and she noted that although the architects of this program had said that, well, this will be a way for access to justice. People who cannot afford the services of lawyers will be able to get a technician to help them with their court forms and their filings, and this will be a good thing. Now, what she has actually found so far, and she notes that the program has not been going on long enough for her to make broad generalizations, but actually people are still being priced out of legal services, even with technicians. She has found that LLTs will now share in this power to resolve disputes that lawyers have, but their responses to a survey that she had submitted to them about how they intend to practice shows that lawyers have made the limited license legal technician program in their own image. So these technicians still rely on the state system, the forms, the courts, the resolutions to assist their clients. So what she actually found is that there's now, at least in Washington State, a tiered system. So you have paralegals, and then above them, you have the technicians. Then above them, you have the lawyers. So people are still getting priced out. So what can we do as librarians? Someone needs legal advice. But first, let's take a survey. Are librarians giving legal advice when they suggest search terms and recommend sources? So if you are on nearpod.com and you have typed in the code, it's at the top of the page here. I've also written it on the board here. You can participate in the survey. Let's take a moment and do that. And I can hide student names. Student
Okay, so far 4 students.
I've hidden student names, just in case anyone's concerned.
Yeah, it just booted me out. I'm trying to get back in.
Okay.
No, it says this survey is already done.
It's already done?
Mine at least.
Yeah, it's not letting me answer either.
It says 100%
Mine said
going in.
install Chrome
Okay,
extension.
so-
I said, no.
Instead of doing the survey, let's do show of hands. Are librarians giving legal advice when they suggest terms and recommend sources? Yes?
Oh, yes.
A few of us? Yes? A few of us? And then how many say no? No. Okay. Would anybody like to share why they had their answer? They did? Yes?
If a patron comes in and says, this is my legal problem, and you say, this is the book you want, you have just diagnosed their problem, come to a legal conclusion, and led them to a source. And if you're wrong, that's their problem, and thus I think you're practicing law, because you're making a judgment.
Especially if they're not doing research for a paper or for a class. You know, if they're coming in and they're saying, oh, I'm going to appear in court soon. Any other thoughts? Yes.
So I work in Access to Justice for the Cali project, but it seems like if it's a should, that's legal advice, so what should I do? But if it is what are the options available to someone in a similarly situated situation, like he and I can both walk in and say, here's my situation, here are my facts, and you say, here are the possible remedies of law, not, pick this one. I don't think that's legal advice if you're saying what someone could do versus what they should do.
Okay, what they could do versus what they should do. Let's hear from someone we haven't heard from. Yes.
So if you have a family law issue, I guess you're deciding that it's a family law issue. But if you come in and you go into family court, and I have one good book that's been written for South Carolina lawyers on family law, and only one, and I give you that book, and I know where the court-approved forms are on the court's website, I just don't see how that's giving legal advice.
Okay, so it's information. They say, oh, I need family law information. Oh, well, here's the family law book, and here's the website that has all the forms. Let them choose their own form. Don't choose their form for them.
I would agree with that. It's not like you're making a legal conclusion based on their facts. You're just giving them the resources to form their own conclusion.
If they say they have a family law problem, if they simply say, this is what's happening in my life, then I think it's a different ball of wax, because I'm now having to make a conclusion that you have a family law problem and I need to give you the family law book. If you come in and say I'm in family court and I need stuff on family law, then I can offer you family law stuff because you've asked for it.
Okay.
But I'm not going to give you stuff on like guardianships and make a judgment that what you really have is a guardianship issue, not a family law issue, because that's me interpreting a legal judgment.
So we have to watch what we interpret. So I'll take one more.
I was just going to say on search terms for searches, oftentimes at a reference desk, somebody will come up and say, I have this situation where this, and this is going on. And oftentimes, instead of taking their search terms and trying to piece words out of what they're saying they're looking for, and say, well, we have this electronic database, like if someone's looking for cases, and say, well, let me show you what kind of search tools that we have, and I can show you how to navigate this resource, and here's the search box. If you choose this filter, it will search cases in the state or federal jurisdiction that you'd like. And I'd say, thinking back to what you were telling me earlier, you can add in some of those keywords that you think would be appropriate to search for your legal issue in this database, and I can show you how to use the database and filter your results.
Okay, so we're showing them the database or the resource, and then they're choosing their own forms, they're choosing their own key terms, especially when they say that I have a legal problem and I need help personally. They're not doing things for academic research. And so it also appears that it's a gray area as well. A lot of it is contextualized, whether it's actually advice or information, depending on what the patron says their problem is. So it's definitely something to think about. All right, so this brings us to resources. Generally, patrons who are not affiliated with a law school don't have access to our subscription databases, such as Lexis, Westlaw, and Bloomberg Law. And there are actually many open access resources which are available to them on the internet. We will not go over all of them today. There are way too many, but there are several that I have found useful. The first one is NOLO. NOLO has been a provider of legal self-help materials, both free through their website and fee-based for nearly 50 years. And this is their legal topics page. It has a lot of information on accidents and injuries pertaining to car accidents, bankruptcy, DUI, DWI, employment law. These are good starting points for people who have nuts and bolts questions. Oh, I'm going to appear in court soon about a family law matter. There are many resources at NOLO. The next resource is the American Bar Association's Fine Legal Help page, which I had mentioned earlier. It has many directories listed at its website. Some are for veterans, some have to do with lawyer referral services. They have links to the attorney rolls of each state bar where people can check to see if a person is licensed. They even have resources for people who might have trouble with their lawyer and need help resolving those disputes. The next resource is from Cornell. It's the Legal Information Institute, which has been in existence since 1992. It provides free access to the U.S. Constitution, the United States Code, the U.S. Supreme Court decisions, the Code of Federal Regulations, and federal rules. Usually, for each state, it has a listing. So if I go to get the law, and then I go to law by jurisdiction, it will provide links to the official homepage, for example, of the judiciary system, or the Supreme Court, or the administrative code. And the state-based websites are often open access, they're free. And last but not least, there is congress.gov, which has a wealth of information. It is run by the Library of Congress, and it has the full text of bills going back to 1989. Now, if people want the full text of bills before then, they would either need to use a subscription database, or they would need to go to a federal depository library and do their research in print. There's a lot of useful information. One common question that I get from people who are not affiliated with the law library is, oh, I just heard about this bill in the news and I would like more information about it. And if it's current or recent, they can actually look it up on congress.gov. There's also the congressional record. There are Senate and House reports here, usually more recent ones. And there are profiles for every member of Congress. So, yes.
Can I mention a resource that you didn't have up there
Sure.
with the ABA, which is the freelegalanswers.org, where somebody can post a question and a lawyer sitting anywhere can pull it and answer it. And so that's good if you don't want to give them legal information, but they have a specific question and they wanted legal advice. My
Sure.
landlord changed the locks, what do I do? That, and it's free.
That's great, freelegalanswers.org.
And it's
Thank
from
you.
the ABA, but I think most states have them, and lawyers, library volunteer lawyers who are librarians who want to volunteer, you get, it's under the 6.5, you get some liability coverage for answering questions on that.
Oh,
So you
that's
don't
good
have
to
to worry
know.
about
Yes,
weighing in and helping people. They make it real easy.
that's good. Thank you for sharing that. So the next point about resources is that some patrons feel more comfortable using print resources. Budgetary constraints may cause libraries to stop purchasing print resources, which leads us to the next question. What will law libraries do to assist patrons who prefer using print resources? Now, the answer to this largely has to do with the law library's mission. And if the law library is attached to a law school, typically their first mission is to serve the faculty and students of that school, and then the general public comes in somewhere after that. Some are even closed to the public. Then there are the public law libraries that are not attached to a school, and their mission generally is to serve the public. So there is a librarian, Kimberly Mattioli, who wrote an article about access to print, access to justice. And she surveyed librarians, law librarians, who served members of the general public. And she found that they said most people who are pro se litigants representing themselves in court, or they are information seekers not affiliated with their law school's library, they're public patrons, use the state and the federal codes in print. And then their second most used resource were the form books in print. Now, Kimberly Mattioli also noted in her article that there are programs that libraries can have to serve patrons who aren't affiliated and who are seeking legal information to represent themselves in court, such as Lawyers in the Library programs, where lawyers spend, say, 2 or 3 hours every week at the library, and they are there to provide legal advice. There are legal clinics that some law schools have that handle legal research questions. There are even self-help materials that libraries can direct patrons to. Now, when you have patrons who not only prefer using print, but they may not know how to use a computer, she notes that these patrons can be referred out to local public libraries, which still have basic computer technology courses, such as how to use email and how to surf the internet. She noted that some patrons, in the words of some of the librarians who responded, are beyond the help of the library, meaning that they may not know how to use a table of contents, or they may not even want to do the research themselves. So librarians really have to be sure of their mission, and they have to know what they're there to do, and recognize that they have a purpose, and you can't give legal advice, and it's not, that you're going to be able to do research for someone who is unaffiliated and be their personal research assistant. So those are other things to think about as well. So here's another survey. Does the library where you work have resources for information seekers who are not affiliated with your institution? So there's no answer, no, and yes. Okay, so it looks like most people are saying yes. 57.1% are saying yes. 28.6% have no answer, but no one has said no. Okay, so most people work at libraries that have resources for information seekers who are not affiliated. Okay. So this is just a short answer. If the library where you work has resources for unaffiliated information seekers, what types of resources does the library have? Do you have form books in print? Do you have public access computers? You can just type that in. Oh, so you have Westlaw Public. It's nice to have a public version of a subscription database. Nexus Uni, public access computers. Okay, so there are some state resources in print. Okay, so it looks like there is a cross-section of materials that are available. Okay, so that's nice to know, that there is a variety of materials. All right, okay. So librarians deal with a lot of difficult situations and different information, and people who come to a library are not necessarily always doing research for their work or for a school assignment. And the next case study that I'm about to mention is called You Killed My Daughter. It was written by A.J. Anderson and appeared in Library Journal in 1992. And the librarian in question noticed that an at-risk youth was checking out a book on suicide. That is why I have the Suicide Prevention Lifeline phone number here, 1-800-273-TALK. But in this particular case study, once the librarian who was working at the desk noticed that the book was entitled Final Exit, and that this youth was from the librarian's neighborhood and was known to be at risk, went to his supervisor, who said that, well, the 1991 White House Conference on Library and Information Services that says that patron information must be kept confidential, and we should not share this information at all. So shortly thereafter, this youth in question who had checked out the book died by suicide, and when the parents of the child found out that the people who worked at the library knew that the child had checked out the book Final Exit but did not notify them, after all, they lived in the same neighborhood, they were concerned and they wanted to speak with the director of the library. So it brings us to the next question, is that many types of situations can come up in libraries, public libraries, law libraries, not always related to just research. To what extent should the records of library patrons be kept confidential? So confidentiality often refers to a professional's duty to keep information secret, and privilege is a legal concept. So we know that we have traditional privileges, such as spousal, priest-penitent, attorney-client. There is no librarian-patron privilege. Courts are traditionally unwilling to extend the concept of privilege to other domains because that will prevent courts from getting the facts for a certain case. But we know that librarians owe their patrons a duty of confidentiality. So let's talk about that. Some years ago, Mark Stover had written about confidentiality and privilege in an article in Reference Quarterly. And he had noted 4 conclusions. And he said there are some times when the librarian's duty of confidentiality to the client must be broken. And the librarian should think of any consequences, including legal consequences, that might occur afterwards. So if we just think back to the case study that I mentioned earlier, what if the librarian had told that particular youth's parents, and the parents had done an intervention and had been able to save the child's life? We can't really guarantee that the librarian would not have received a backlash that people would say, oh, you saved a life. So there's a lot to think about in that. Stover also noted that there can be a conflict between confidentiality and ethical freedom. meaning that there are some questions that librarians are asked to research, and even they need help finding the answer, and they may want to consult with someone else. Typically, they will need to get permission from the person who wanted them to research the issue. Now, I have here listed the Code of Ethics of the American Library Association, the professional competencies for reference and user services librarians of the Reference and User Services Association, which is a part of the ALA, and the ethical principles of the American Association of Law Libraries. They all have a web page with all of their ethics listed. Now, a long time ago, Mark Stover in his article said that, well, these librarians' ethics are so vague. These ethics from the ALA are so vague. They don't define privacy and confidentiality. Well, they still don't define privacy and confidentiality, but the ALA has many web pages with facts, with questions and answers, with interpretations of the Library Bill of Rights that give examples of what it means to keep patron information confidential. For example, libraries are keeping patron information confidential when they do not monitor where people go on the public access computers. So, for example, they have the computers set to erase the data at the end of the user's browsing session, or they don't have spyware installed. For example, libraries are protecting patrons' confidentiality when if they have surveillance cameras, they have signs up saying, this area may be under surveillance. However, they will purge all of that footage when the law says they can purge it, or as soon as possible. So those are just a few of the examples. Other examples include the fact that libraries should be educating their employees, even the volunteer employees, on what it means to keep patrons' information confidential, and they should be doing regular privacy audits. So there are a lot of examples today in various materials from the American Library Association at their website that give examples of privacy and confidentiality. And this is a screenshot of the questions and answers on privacy and confidentiality. And the main guideline from the ALA is acquire as little personally identifiable information from the patron as possible for the least amount of time. And they also note if you must release this personally identifiable information to the patron, that you should have a court order from law enforcement. It shouldn't be something that you just hand over. So it's also helpful to note that 48 states and the District of Columbia have statutes that address the confidentiality of library records. So they say that there should be some confidentiality there. The states that don't, Kentucky and Hawaii, have state attorney general opinions that address the confidentiality of library records. And the American Library Association has a website listing these particular statutes. And here is the state privacy laws regarding library records website. So here's something for us to think about. Do information seekers expect librarians to keep their research questions confidential? I would say it depends on the patron. I came across an article by Rosemary Del Vecchio, who was a humanities librarian at Skidmore College, who noted that students would come to the reference desk with their friends. They didn't expect privacy. She said one student even told her that he didn't need privacy, but she noticed that the faculty would not come to the reference desk with their questions. They would ask their questions one-on-one. They expected privacy, or they would ask their questions over the phone. So it's something to keep in mind what different patrons expect. So another issue related to privacy has to do with national security letters. This is a warrant canary sign that many libraries have started to post. Well, some libraries have started to post. The FBI has not been here. Watch very closely for the removal of this sign. This particular sign was created by Jessamine West, who works at the Kimball Public Library in Vermont. By law, librarians can say the FBI has not visited them. However, if they get a national security letter, which is usually accompanied by a gag order, then they can't really talk about it. So maybe they had a sign up and they just removed the sign. So the sign is called a canary, because 20th century coal miners would often take a canary with them into the mine, since canaries were more sensitive to carbon monoxide. If the canary died in the mine, then the miners knew that they needed to get out quickly. So we see that the canary has applications in other contexts. And that sign and others like it may actually be found at librarian.net, which is Jessamine West's webpage. And this is her Twitter feed. Okay, so we do have some time for questions and answers. I'm not sure if we'll get to our group discussions, we'll see. But questions, answers, comments, if something occurs to you after this session, and feel free to email me at latiaward@cornell.edu. Questions, answers, yes.
To your knowledge, has any librarian in the history of the world accused of the unauthorized practice of law, meaning taking it whether to a bar complaint or even a legal complaint or something like that? So do you have a sense of where these complaints have gone, if they've been made?
To my knowledge, no. So I have not heard of that happening. Any other questions or comments? Yes.
Just a comment on kind of the general state of transitioning from, having lots of print resources to more and more going online. It seems like a somewhat common occurrence is you may have a print set that's been in your library for a number of years, and then as it's updated, it then becomes an online-only resource, or perhaps the license was bought by one of the larger companies that produces the online databases, and then all of a sudden you have a dilemma where a patron was able to come in and take a look at the print resource, but all of a sudden this resource is now part of a database that would require a login or would require additional licensing. Have you seen in some articles written about that, or seen different ways of handling that kind of situation?
That is not something that I personally have experienced. However, I know that that's a really difficult situation if a patron was used to getting one particular resource and now it's behind a paywall or it's no longer available in print. Which, if there is an alternative that is open access and that is free, then it will be good to give the patron an alternative to that, if possible.
Thank you.
Yes.
I work with Erin, and I think what's happening with us is for lawyers and patrons, or public patrons, is that book that I'm not gonna be able to get anywhere else was available, because we only have 2 law schools here in South Carolina, we're the public one. It was available, and now it's on Westlaw Access, and we canceled the subscription to the print. And now it's no longer available to us. I understand that's not a big problem when a lot of libraries don't even have the print collection that we do, but we have it because we're pretty much, we don't have a state law library, we don't have public law libraries. We keep everything. And then now we're having this, I'm sorry, that's just on Westlaw, just all access, and by the way, we can't give you access to it.
Right, that's a really difficult situation. It's a really difficult situation. And in situations like that, I would say librarians try to look for an alternative somehow. Maybe there's another resource that has similar information. Yes?
Public access, we have one public access Westlaw terminal, and it's not cheap by any means, but I guess you have to weigh it against the cost of maintaining all of those print subscriptions that are on Westlaw.
It's true.
So at that point, I mean, we have a whole lot of print books and we sticker them very carefully when they're out of date. We say last updated, things like that, or current version on Westlaw. And again, we only have the one terminal, and thankfully there's not a lot of times that we have to throw people off after our half-hour limit. But that's just, it's a balancing act with the cost, because if there's gonna be a lot of this information on Westlaw,
Right.
then it might be cheaper to subscribe to a public access subscription from Westlaw. The downer, of course, to that is if Westlaw decides they're no longer putting out their public access subscription.
Right, are you getting some treatises on it?
We actually have a pretty robust public access.
Our public library system here has open access Westlaw. That we do have that for all of their librarians in the same in Greenville County upstate. We have Nexus Uni, it's paid for by the university,
Right.
but the treatises aren't on there.
It is better than trying to teach the public how to use the digest system.
Oh, Lord, yes.
Okay, so online resources have their advantages, yes.
It seems to me that there is, we're talking about the access to justice gap as you can find information, you can't find information, but there's also a kind of gap in the good resources are here where you have to pay for them, or you have the make-do resources that typically aren't as good, and that is a different gap between the haves and the have-nots.
Right, for example, many times you may not have the updating services or the citators where people can check to see if their law is still good law, if they are getting their case law from an open access database. So that is another gap as
So they
well.
can't get annotations.
Can't get annotations, that's another gap.
Even with print materials. Like, if you're California, NOLO will do California books. But if you're South Carolina, not happening. So you don't have state-specific material. Sorry, could you?
Right, so there's many gaps.
I've noticed that oftentimes the clinics available at public law libraries are only open, during certain hours and tends to be doing a work day. Have you seen anybody that's doing like e-clinics? Think about the rise of telemedicine, and that's kind of a hot way for people, especially in rural areas, to get medical advice. Have you seen that at all for?
E-clinics, that's something I hadn't come across, but that sounds really interesting. I'll have to look into that, yes. Yes.
They've been doing it in South Georgia, Dougherty County, their county law library, because they just don't have enough lawyers down there. So they're linking in to lawyers in Atlanta where all the lawyers are to help folks. But those appointments tend to be scheduled through the county law library, and then they're using, technology to
Presuppose that you have access to a computer and.
Right, like all of these creative things often are, that can be a barrier to somebody who, really doesn't
Cool, they're trying.
have information. Yeah, because all our lawyers are in the city, and all the poor people who need the lawyers are out in the country.
Right, so clinics should be flexible.
Yep.
Definitely. Yes.
There's also a lot of legal aids across the country that have two things. The clinic part that you mentioned where you can work through a document assembly project and share your answers then with a lawyer at the legal aid who can, do a short little yes, you're doing the right thing, you're in the right form. They can give that little bit of legal advice if the person can do the bulk of the form filling through the software. But they also have statewide websites. You mentioned Law Help. Lawhelp.org shares all of them, but each state has some form of a legal aid website that's funded through Legal Services Corporation. And they have a lot of live chat on there. So law students do that a lot, where they can help find resources on the legal aid websites and help direct them to a lot of the stuff that legal aid is building a lot of this content to, or court resources, that kind of stuff. So there's always a live chat option on a lot of websites.
That's good. That's real good. Any other questions, comments? Is that?
Get off my soapbox after this, I promise, but, you mentioned the free legal resources being kind of a lesser tier, and we're coming up with, various counties trying to reach out, The real problem, from my perspective, is that all of these are great things. They're important in ways we can contribute, but they're kind of Band-Aids on a bigger problem. So, I mean, to solve this problem as a whole, I think personally that's going to take an investment from states, from the federal government, to make justice accessible to the masses, so to speak. And whether that's more legal aid money, whether that's making different policies for protecting law librarians from liability, or these technicians you mentioned, I don't know what protection they have from, can they be sued for malpractice, can they be grieved, I don't know. But unless we come up with bigger systematic solutions, I worry that there's just not really a big uniform fix for this that we can provide at least.
Right, so the access to justice problem, someone who comes to a library and they're representing themselves in court, is actually a part of a larger problem, you know? So even if they can get some information that they need from an open access database, do they really have the wherewithal to represent themselves? Do they have the wherewithal to be able to sift through all of that information and figure it out on their own? So there's a huger problem that has to deal with access to justice and being able to get a fair resolution to one's dispute.
On that cheerful note, right?
But it
Yes.
shouldn't stop you from
Well,
trying.
yeah, we do the best we can with what we've got, yeah.
Well, I mean, and the reason I asked the question about if you knew of any cases is, I'm sorry, but we are using this unauthorized practice of law thing to stay in our little hidey holes and perhaps not stepping up and doing as much as we can. We've been using that for decades now, and it's kind of has to stop. You know, when you have things like paralegals and they can be covered by their firm and all these things, there are mechanisms, there are ways to do this, whether we do it through clinical coverage and the students are covered. We, the librarians, and I'm going to lump myself, we choose not to do this. And again, we're sticking our heads in the sand, not contributing and making a difference when it's so desperately needed. And we got to get over that crap. That's my personal opinion, not my institutions.
Their thoughts?
I do some training for non-law librarians because they tend to be really worried, public librarians, about the unauthorized practice of law. And I always say I've not heard, and I've done the research, and I can't find a librarian who's been prosecuted for unauthorized practice of law. Of course, I was sitting in a state that it was a misdemeanor, and then we made it a felony to practice law without a license. And the only law on the bar's website, because they have all these little brochures where they tell you about landlord-tenant, and they tell you about this and they tell you about that. Not a case cited, not a statute cited. It's all lay stuff. Then you get to the UPL section, and it's all these cases and all these examples. And in South Carolina's in textbooks of, UPL problems. You can't give legal advice. Don't tell about a form. And this one guy just helped his neighbor lady fill out a will. But since he wasn't just the scribe, he was in trouble. They did nothing to him really but say, don't do it again, stop doing that. But it is a felony and they're scared to death. So it's not really us, I think it's not the lawyer librarians who are probably no longer practicing or whatever. But we got to do it across the board, educate folks that say this is what you can do, not think about what you can't do. Let's give them that information and get as much knowledge as we possibly can. Know your collection. Know every book that has a form in it. So you can say, okay, here's the book we have that has, the person who's written it, lawyer in South Carolina, has managed to put forms, and that's how we deal with it. If you think about it and you think about the big picture, you'll be so depressed. You won't be able to sleep at night because no one can afford any help. If you have Westlaw in a public library, the librarians tell me, yeah, well, we've got it. But it's almost impossible to actually get people knowledgeable about it, because they're overwhelmed with the database. So we just take little pieces, you know, just keep rocking, you know.
They probably have a Westlaw rep for the library. I mean, I know we do it at the law school, and we have them come in, they do classes, you know, introduction for the 1Ls especially. So I wonder if they could call their Westlaw rep and have a class.
That is called us, and that's fine.
Mhm.
We're gonna do it, but, it's
you know,
just, the money's not there for the Westlaw reps. It's in a small, they have 2 counties that have it. I've been there. But we like doing it, so it's fine, but you can count on 2 hands how many law librarians you have in the state.
I mean, I wish we could do more personally, but no one wants to be that first person who's prosecuted for crossing the line. The truth of the matter is, I don't think someone should have to stick their neck out. I think the states have to come out and say,
I agree.
this is the protections we're offering librarians, this is what you can and can't say, this is what you can and can't do. Because right now it's trial and error until somebody crosses the line and we get some kind of
Or
ruling.
provide legal services.
Okay, and one more over here, and then we'll wrap up. Saw his hand.
He said part of what I was thinking, and he said it earlier, in that you need some sort of indemnity system. I hear and I resonate with the fact that in this state, it is a felony.
Yeah.
Nobody wants to be that first felony, especially since that would lead you to be disbarred if you are a member of bar associations.
Mhm.
But there's also a civil liability side, there is an ethics side. So I was looking at Rule 6.5, which was mentioned earlier, which talks about what lawyers can do and conflicts of interest. And it's not a conflict of interest if you don't know it's a conflict of interest. But that seems kind of nebulous. So here comes somebody, and lawyers get clients like this all the time, where they don't like the result, and they come back at you and they're like, here's the ethics complaint. Well, now I gotta spend 2 days responding to an ethics complaint, or worse, they file a malpractice suit, and now I actually have to incur court fees defending myself with the potential of having a judgment. And to me, that is a far bigger deterrent than the felony. And we can say, till we're blue in the face, well, no jury's going to convict you. I still have those expenses and that time and those costs, and I don't want to be the first one there. I want a bright line rule where I can walk in and say, summary judgment, I cannot be held liable for this.
And on that subject, universities have very deep pockets. So if I'm working at a university or a law school reference desk, and they come after me, they're gonna come after
Oh, yeah.
my institution. And even if, like you say, we win, there's court costs, and then there's my job. You know, because they're not gonna wanna, they're not gonna wanna keep employing a librarian who's gonna be sued.
So we've come up with a whole lot of useful ideas, of thoughtful ideas. Our group discussion has been really productive. I have 11:58 on my clock, and I know we probably want to eat lunch. So I'm just going to wrap it up. So there's gray areas. There are not a lot of definitive answers, but we all seem to have reached a consensus that libraries and librarians can do more to help people. And legal clinics can play a huge role in that. If you go to the short URL, you will have resources from today's session. It actually leads you to a Dropbox folder. The articles that I have mentioned here, the websites from the American Library Association are there. In the resource document, there is actually a link to a Zotero.org bibliography. I've created it, and you can join if you like. And it has the citations for the different articles. So a big part of this is the fact that librarians just need to recognize that there is a justice gap and that we can facilitate access to justice through providing information. Okay, we know that we're not giving legal advice. We can direct patrons to appropriate resources, and we can keep patrons' records confidential where necessary. But this is only the beginning of a dialogue, and this is something that we'll have to keep talking about and working through.